Hello students, welcome back to our class on intellectual property rights. Today we are going to discuss author and ownership rights conferred and term of copyright. So there are three topics we are going to discuss today in this class. How to claim authorship of copyright, how to become an owner, or who is the owner, then what are which are the rights conferred by Copyright Act on us as a copyright owner, and then how long do I have this particular right, the term of copyright. So let's start. So in my introduction, I would like to say that the concept of author and ownership are very essential to establish proprietary rights over the copyright. There is no copyright in idea. I have already discussed this. It is the originator of idea is not the owner of copyright unless he is also the creator of the work. This was held in the case called Donogh versus Allied newspaper. Section 17 of Copyright Act 1975 says that the author of the work is the first owner of copyright. He is the first owner of the copyright. So this is very essential and very important. Now you can see the person who is writing the book is the author. He might have, anyone might have given idea to him to write a particular book, say for example, on a particular issue. Now the person who is telling him to write the book is and giving him an idea is not considered as copyright owner. It is the person who actually writes the book and he puts all his efforts and brings out a nice book is the true owner. Similarly here, the person who is giving idea to a producer, that person is not the owner of the film. Who is the owner of the film? The person who is producing that film. Okay. Now here the same thing. The person who paints a beautiful painting is the author of that painting. Let's go ahead. Now, what are the provisions of Copyright Act as far as authorship is concerned? Section 2D defines author in various categories as under. First, if it is a literary or dramatic work, the author of the work. That means the author of the work is the owner, the person who has created this literary or dramatic work. In case of musical work, the composer of the music is the author, the first owner of the copyright. In case of an artistic work, the artist. In case of photograph, the person who has taken the photographs is the owner or author of the or the owner of the copyright in the photographs. In case of cinematography, the producer of the film is the owner. In case of sound recording, the producer of the sound recording is the owner. In case of literary, dramatic, musical or artistic work, which is a computer generated work, the person who generates such work is the author. Now here you can see this is a scene from a very famous and blockbuster film called as Avatar. This is a computer generated work. Similarly here, a technology which is used to create that particular film is called as facial animation. Okay, facial animation technology. That means what all the points on the actors will be notified, and then the same thing will be copied and generated into an electronic form, in a graphical form, digitalized form, and the author is converted into a cartoon character, which will have the same kind of expression as the real human beings. This is technology, and the person who has put his labor, skill and capital in creating this particular creation, a beautiful creation, a movie, is the true owner of the copyrighted work. Let's go ahead. Whether there is any need of nationality requirement for the ownership of copyright. Let us see now. There is no such condition in India. Indian law, but the subsistence of copyright has certain requirements under Section 13, Clause 2. That means what? If you want to claim copyrights, you must have certain essential requirements. Then only you will be able to claim copyright in your work. Now let us see one by one which are those work, which is that work. If the work is published work, the work must be published in India, or when published outside India, the author must be a citizen of India at the time of publication. If that is the case, then that person can claim copyright. This is an essential requirement after work is published. Next is unpublished work. If the author at the time of making the work must be a citizen of India or domiciled in India, then only an unpublished work can be claimed by that author. Then architectural work. In case of architectural work, the work must be located in India. Then only a person can claim right in that architectural work. You can see a picture. This is an architectural work. Now this building must be located in India. Then only you can claim rights in the as copyrights in that particular work. Let's go ahead. Let's come to the ownership of copyright. Section 17 of the Act recognizes the author of the work to be the first owner. The author is the first owner of the copyright. However, there are certain exceptions. In case of literary, dramatic, or artistic work, Section 17A says that when a work is made by an author during the course of his employment, he will be the first owner. There's one case here, Thomas versus Manorama, which was decided in 1989. It was held by the court that in case of termination of the employment, the employee is entitled to the ownership of copyright if the works created subsequently and the former employer has no right over subsequent works so created. Now, what is the meaning of this? That means as long as that person was under employment with that particular employer, whatever orders are given or whatever work was assigned to him, he used to create that particular work, right? And the owner of that particular employment, that is the employer, used to claim copyright ownership in that particular work because he has hired him to do that particular work. Now, if the work is terminated or if the job is terminated and he is no more in that particular employment and he continues creating those kinds of work on his own, now who will claim the copyright? Now this time it was held in this case that the earlier employer cannot claim copyright in the work of the former employee if he creates that work subsequently after termination of the employment. So the owner cannot take objection and claim copyright in that case. Right. The copyright in a work done by an employee in his own time and not in the course of employment belongs to him. Let's go ahead. In case of photograph, painting, and portrait, Section 17B says that if a photograph is taken or a painting or a portrait is drawn or an engraving or a cinematograph film is made for consideration, that means for money, at some person's instance in the sense somebody has ordered him to do so. Such person, that means the person who orders, shall be the first owner of the copyright. Suppose I have a photograph shop or a studio. Now somebody is working for me as cameraman, right? So I assign him the job of taking the photographs of the wedding anniversary or any program. Now whatever photographs are clicked by him belongs to me. Why? Because I pay him salary. So he is acting within the employment. So I am the true owner, right? Because It is on my instance he went there and took the pictures, right? Okay, let's go ahead. Work made in the course of employment. Section 17C says that if a work is made in the course of employment under a contract of service, see, I have been hired for a particular period of time, and the employer directs me or gives me that particular assignment, and if I does that particular thing, create that particular work, then I cannot claim ownership in that. Why? Because the employer has hired me. So in that case, the employer will be the first owner of the copyright. Next, lectures delivered in public. Section 17C says, if any address is delivered in public, the former is the first owner. If delivered on behalf of someone else, such other person is the owner. So, say for example, if I'm the program coordinator, I have organized a particular program, and if I ask Mr. So and so to give a public address or to give a lecture, now all the rights in that particular lecture belongs to me. Why? Because I am the owner of that particular program. If I myself go out in the public and gives lectures to the public on my own without anybody's control, then I am the owner of the lectures. Let's go ahead. Government work. Section 17D says that the government is the owner of such work. Whatever work is assigned by the government is the owner. Work made on behalf of public undertaking. Section 17DD says that such public undertaking shall be the owner of the copyright. Work of certain international organizations. Section 17E. In such case, the international organization concerned shall be the owner of the copyright. Let's go to the rights conferred by the copyright. What are the rights conferred by the copyright? Now, what is the nature of the copyright? It's a statutory right. Copyright is a statutory right. Then it is also a negative right. It also consists of multiple rights. It is also called as economic rights and moral rights. Let's see one by one. Statutory right. Copyright is the work that is creation of statute. That means the law gives the right to the rightful owner of a particular work done by him. Law recognizes the work of the owner under section 14 of the Copyright Act. Now, this picture has been drawn by someone, and this painting has been done by someone. That person gets the right from the statute. Next, this is a drama. They are acting. On whose behalf? The person who has written that scene, that drama. That person is the owner of this particular drama, the producer. Next, this is the picture of a wild animal taken by a photographer. That person is the owner of that photograph by virtue of the Copyright Act. So therefore it is called as statutory right. That's why negative right. Why it is called as negative right? It stops others from exploiting the work of the author for their own benefits without the consent of the or license of the author. Now here you can see the picture. A person is committing piracy. You know what is piracy? Video piracy. It is called as video piracy. This culprit, he downloads the movies from the internet, and by way of some breakage of security, he breaks the security, he breaks the codes, he breaks all the passwords and all those things, and then downloads a particular movie in a crystal clear manner, and then he makes copies of those movies on CDs, DVDs, or makes it available as a streaming video without the permission of the true owner, that is the producer of the film or the producer of the video of a movie. And then this, to stop these kind of things, copyright law gives an author a right which is called as negative right. That means as I'm the author, I can prevent others from copying my work. I can take action. Next is multiple rights. Copyright is not a single right, but a bundle of rights. It's a set of rights. These rights can exist and can be exploited independently. The nature of these rights depends upon the categories of the work. Now, in a movie, there are so many rights. Rights of video recording, then rights of the actor's performance, rights of music composed in that particular movie, and all the songs in that particular movie, everything belongs to the studio, the art, the scene of the particular movie, everything, all the photographs from that particular movie, still images, everything belongs to only one person. That person is called as the producer of that particular film. Therefore, it is called as bundle of rights. Next, economic rights. Section 14 says that the author may exploit his work by himself or license others to exploit any one or more of the rights by consideration, that is, for money in the form of royalty or a lump sum amount. Okay. Now, if I have written a book, I can go to the publisher and either I can sell all my copyrights to him so that he need not ask me anytime. Whenever he wants to print more copies of my book, there is no need to ask me. But if I have reserved all the copyrights to myself, to the author, then the publisher has to every time confirm or every time ask me how many copies do you want of a particular book, and I will be paid royalty on all those copies which are printed by him or published by him. Moral rights. Moral rights are such rights which are as under: right of publication, to publish or not to publish my particular work; right to claim authorship of a published or exhibited work; right to prevent alteration and other actions that may damage the author's honor or reputation. All these rights taken together are called as my moral rights. Now let us come to the term of copyright. How long I can have protection under Copyright Act of my work. The term varies. It changes according to the nature of the work. Now let us see one by one. Section 22 says that speaks about the term of copyright in literary, dramatic, musical or artistic works. Copyright shall subsist in these particular works within the lifetime of the author. That means as long as the person is alive, until 60 years after his death. Section 23 speaks about term of copyright in anonymous and pseudonymous works. Anonymous means there is no need, we don't know who has written or we don't know who has created that particular work, so that is called as anonymous. So the copyright shall subsist in that case until 60 years after the work has been published. And that means from the time of the publication of the work till 60 years, he has protection so that nobody can copy his work. Section 24 deals with term of copyright in posthumous works. Posthumous means suppose the author dies before publication and his book or his creation gets published after his death. So how long that protection can last? In that case, copyright shall subsist until 60 years after the work has been published. Again, Section 25 deals with term of copyright in photographs. Copyright shall subsist until 60 years after the photographs were published. Section 26 deals with term of copyright in cinematograph film. It subsists until 60 years after the film is published. Section 27, term of the copyright in sound recording. Subsists until 60 years after the work is published. Section 28, term of the copyright in government works, public entertainment. Subsists until 60 years after the work is published. Section 29, term of copyright in works of international organizations. It also subsists until 60 years after the work is published. Section 37.2 deals with broadcast reproduction right. Now, broadcast reproduction right in the same live telecast or anything which is published on radio, TV, all those things. Here also the rights shall subsist until 25 years after the broadcast is made. So here only 25 years are available, okay, for the protection after the broadcast. Section 38 clause 2 speaks about performers' rights. It shall subsist until 25 years after the performance is made. Now who is the performer? Performers are lecturers, singers, actors. Their performances are protected by way of performance rights. Okay, for 25 years after the performance. Now that's all. Thank you so much for patiently listening to my lecture. We are going to deal with our next class in my next lecture. The name of the lecture is Assignment or License of Copyright. See you soon. Thank you so much.